Good evening. How's everybody doing? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. Who's in the house? Stephen in New Hampshire, Joe in the Inland Empire, Yehud in South Carolina, Tom in PA, Karen in Northern California, Lucy, Minnesota, Bella in Florida, Jonathan in Southern California, Sharon in New Jersey, Melissa in Great Neck, Bill in Mid-Missouri, Ella's in the house, Frank in San Pedro, Chaim in Florida, Rochelle in Minneapolis, St. Paul. Welcome, everybody. Starting a new chapter, chapter 6, here in Tractate Bava Metzia, the 22nd volume of the Talmud. Chapter 6 opens at the very bottom of page 75b, and our daf today is page 76. Let's do it. This chapter is going to be concerning hiring people, right? So on the one hand, you hire an employee who becomes your employee. Sometimes you hire a laborer for a specific job for a period of time. And sometimes you hire a contractor. And these are going to form different relationships with different liabilities. Mishna number 1, chapter 6. With regard to one who hires artisans or laborers, right? So what are artisans? And the early commentaries explain that whereas the term laborers refers only to those hired for a fixed period of time, artisans is a general term that includes laborers as well as contractors who are hired to perform a specific task. And they note that this is not invariably the case, as the term laborers can occasionally include contractors as well, but nevertheless the term artisans apparently has a broader connotation. So very important whenever we're using these terms to think about what context are we talking about, what kinds of people are being hired to do what. Are they hired to do a job and we'll see how long it takes? Are they hired to work for a certain number of days? Let's see. But with regard to one who hires artisans or laborers, and they deceived one another, they have nothing but a grievance against one another, and they have no financial claim against the deceptive party. This is not some kind of general concept that people who deceive one another have no claim. The Mishna will explain what we're talking about, and the Gemara will further narrow where this kind of thing applies. One of the first questions we should be asking is, with regard to one who hires artisans and they deceived one another, who's deceiving who? The artisan and the employer are deceiving each other, or the people who are being hired are deceiving each other? As we'll see, it can mean both things. If one hired a donkey driver or a potter to bring posts for a canopy, or flutes to play in honor of a bride or the dead, or if he hired laborers to bring up his flax from the retting tub, which is how flax is processed into fiber, and this is the first stage of the manufacture of linen, and likewise any matter that involves financial loss if not performed on time, and the laborers who were hired reneged. So if this occurred in a place where there is no other person to perform the task, then the one who was hiring may hire replacements for a large fee at the expense of the first workers, or deceive them to get them to return to work. And the Gemara will explain what we're talking about when we say deceive them in that context, right? But it's a big difference. You hired somebody, they agreed to come, okay, and then they don't show up. All right, so you go hire other people. But what if you were relying on them to come and there's no other people to hire, and because they didn't come, you have a major problem, like the people who are going to come set up a wedding, or the people who are going to get a house built before the rainy season began. This kind of thing can end up costing a tremendous amount of money. So if there's no one around to hire and they agreed and said they were going to be there and they're not, or they came and they started the work and then they just left, because maybe they got a better offer somewhere else, and now the one who was hiring them is really got problems. So here he definitely has a claim against them, and he can go hire replacement workers even if they're very expensive, and he will be able to get those first workers who shirked their responsibility to pay for the new workers. So there's a big incentive for those workers not to behave in that manner. And it goes in reverse too. If the employer said he was going to employ them, they relied on him, and then he doesn't do it, they're going to have a claim on him, depending on how far they got, especially if they started the work and then he says, forget it, they're definitely going to have a claim against him. Now, the Mishna states, the Mishna states a related halacha, related law, with regard to one who hires artisans or laborers to perform work, and they reneged on the agreement midway through the work. They are at a disadvantage. They must ensure that the employer does not suffer a loss, pretty much as we just explained a moment ago. We mentioned that one of these kinds of workers are flutes to play in honor of a bride or the dead. So there's an interesting note here with this little picture. This is definitely a digression, but I found it very interesting. All right, so you see that. That is a Greek drawing from the 5th century before the Common Era of a woman playing an aulos, it's called. I'm sure I'm pronouncing that wrong. Now, in the Mishnaic period, right? So the period of the Mishnah, now we're talking about from the end of the late Second Temple period up until about the year 200 of the Common Era. So in the Mishnaic period in the land of Israel, it was customary to play flutes or similar instruments at a funeral. And this custom was considered so important that it was even permitted to transport the instruments for this purpose in a halakhically problematic manner. In later generations, however, this practice was abandoned as it had become regarded as a Gentile custom and inappropriate for Jewish funerals. So I thought that was quite interesting. Okay, last line of the Mishnah. Conversely, if the employer reneges after the work has begun, he is the one at a disadvantage, and these two rulings are in accordance with the principle that whoever changes the terms accepted by both parties, he's the one at a disadvantage, and whoever reneges on an agreement is at a disadvantage, right? If you renege, you're the one causing the problem, and you are going to find yourself at a disadvantage as we sort out who owes what to whom. Okay, that's the Mishnah. Now the Gemara. The Gemara starts by analyzing the phrase, and they deceived one another. The Gemara comments, the Tana of our Mishnah, right, the sage, the rabbi who composed our Mishnah, does not teach that they reneged on the agreement with one another, which would indicate that either the employer or the laborers changed their mind. Rather, it states that they deceived one another, which evidently means that the laborers deceived one another. Why does it mean that? Let's just continue. The Gemara therefore inquires, what are the circumstances? And the Gemara explains this is referring to a case where, for example, the employer said to one of the laborers, go and hire laborers for me. And that laborer went and deceived the other laborers. Right? One guy came over to do the job. He and the employer agreed it was going to take more guys to do this job. So the employer said to the laborer, go find some more laborers. Now, maybe the first guy was hired to work, as we'll see, for 4 dinars a day. And now they realize they need more guys. So the employer says, go hire some more guys, at the same rate, 4 dinars a day. This guy goes and he finds people and he tells them, I've got a guy, I got a job for you. It pays 3 dinars a day. He's acting as a middleman. He's thinking he can pocket the difference since he's now acting not so much as a laborer, but as a contractor, as a middleman who's going to bring more workers. Is he really being deceptive? I mean, he did go to the trouble of finding these new guys, right? It's going to be his reputation on the line. If they do a bad job, he's going to take it on himself to supervise them. Nevertheless, the employer just said, go find more guys like you. I'll pay them the same as you, and he's paying them less so that he can pocket the difference. That does smell at least deceptive. So the Gemara asks, what are the circumstances of this deception? If the employer said to him, hire for me laborers at 4 dinars, and he went and told them that they are hired for 3 dinars, so what is the relevance of this grievance? After all, they knew and accepted the conditions of their hire. They agreed to work for 3 dinars a day. Who was deceived? What grounds for complaint do the other workers have? If the employer said to him, hire laborers for 3 dinars, and this laborer who's now become a middleman, went and told the workers that they would receive 4, so then what are the circumstances? If he told them at the time, the monetary value of your services, i.e. your wage, is incumbent upon me, well, then let the middleman give them the difference from his own pocket. The employer said, find me some guys that'll work for 3 dinars a day. For whatever reason, maybe he couldn't find guys to work for 3. He found guys that will work for 4, and he said, well, come and do the work, because maybe he needs to get paid, he needs to get the work done, whatever. So he's offering to pay them more than the employer offered. Now, the employer never agreed to that. If this guy feels like he has to get those people at that rate, well, then maybe he's going to have to make up the difference out of his own pocket. And this is as it is taught in a baraisa with regard to one who hires a laborer to perform work in his own field, right? I'm hiring somebody to work in my field. And the employer inadvertently showed the laborer a field belonging to another in which he should work, right? I brought him to work on my field. I got confused. I don't visit my fields that often. And I actually said, okay, start harvesting here. And it wasn't my field. It was my neighbor's field. Ooh, so then what's going to happen? So then the employer must give the laborer his full wages. And in addition, the employer can go back and take from the owner of the neighboring field in which this worker did his work, the value of the benefit to that owner that he received from the laborer. The employer is entitled to claim from the owner of the adjacent field the profit that the owner gained from that work, but not the entire wages of the laborer. Which is, so it's like you'd have to measure, okay, what was that field worth after it's been, partially harvested compared to what it was worth before, and that amount of money is what the neighbor benefited, and I can ask him to pay me that. But I can't ask him to pay the full wages of this laborer who spent the day there. But this indicates, the point of this is that it indicates that the one who says your wage is incumbent upon me must pay the specified sum. Now that I brought him and I made a mistake and put him in the wrong field, I can't say to the worker, hey, you know what? I want you to work for me. Sorry, I showed you the wrong field. You go and talk to my neighbor. You worked in his field. He'll pay you. No, I can't say that because I hired the laborer. I gave him the erroneous information about where to do the harvesting. And I said I'm hiring him, so I need to pay him. Maybe I can get reimbursed for some of that from my neighbor, but between me and the worker that I hired, I need to pay him. Now the Gemara explains, so it is necessary to state this law where the middleman said to them, the obligation to pay your wages is incumbent upon the employer. So when the middleman went and hired other people, we're back to the original case now of our Mishna. So I hired him. I said, we realized we're going to need more guys. He went to hire other guys. And then when he said to them, and then I'm going to hire you for 3 dinars a day, he didn't say that. He said, come work. I'm doing some work. You'll work alongside me, and our employer will pay us. He'll pay me and he'll pay you. So he's not saying that I'm hiring you as the middleman. He's saying I'm going to bring you to where you will be hired. So then if he said that the obligation to pay your wages is incumbent upon the employer, and it subsequently became apparent that the employer was not willing to pay that much. So in this case, the laborers have a grievance only against the laborer who hired them because, the employer never granted agency to that middleman to go hire people at this higher rate. He never authorized him to do that. The guy just made that up himself. Now the Gemara challenges, but let us see how much laborers are hired for in that place. And the employer should pay them in accordance with the accepted custom. So the accepted custom, the going rate, what workers can expect to make. When you send this middleman to hire people and you say, well, go find guys who will work for $1 a day. Well, there's no such thing. What he said was go hire workers. I'll pay them this. But if what he said was unreasonable, then he has to realize that if workers come and do the work, he is going to be held liable to pay them the market rate according to this view. So he should pay according to the accepted custom. And the Gemara answers, no. It is necessary in a place where there are those who hire for 4 dinars and there are others who hire for 3. Now it's more interesting. So there are, in some locales, there are 2 different rates. So probably the more reliable, more experienced workers can command 4 dinars. And the less reliable, less experienced workers get 3 dinars, right? So there's 2 rates that are available here. And the reason that these guys have a grievance, right, if they were told that they're going to earn 4 by the middleman, and then it turns out that the employer is only offering 3, now the reason that they have a grievance is that the laborers can say to the middleman, well, had you not told us that you were hiring us for 4 dinars, we would have made an effort and found another employer where we could get 4 dinars. And we would have hired ourselves out for 4 dinars. So consequently, you, the middleman, caused us a loss. Now that we have to work for 3 dinars, you owe us the difference. And if you wish, say that the Mishna is referring even to a place where there is a fixed wage for all laborers. But here we are dealing with a homeowner, i.e. one who usually not accustomed to doing labor, right? So one who hires laborers but doesn't do work as a laborer. But in this case, he was hired for his services, right? Why would somebody do that? In order to supplement their earnings. Such people will occasionally work for others as well. This is a homeowner. He doesn't need to be a laborer. But okay, he's saving up. He's got a wedding coming up for, 1 or 2 daughters. He needs extra work. So he hires himself out in addition to whatever he makes from his homestead. He's going to go do some hired labor work. And so when this middleman came and said, I've got some work for 4 dinars, this guy came. And the reason for their grievance is that these laborers who also own fields in their own right say to the middleman, had you not told us that we were hired for 4, it would have been too demeaning for us to be hired, as it is not worthwhile to work in the field of another for so little when we have our own plots of land to work. This is the cause of their grievance against the middleman. And if you wish, say that actually we are dealing with regular laborers, not a homeowner. And the reason they have a grievance is that they say to the middleman, since you spoke to us of 4, we made an effort to do higher quality work for you. And the Gemara challenges, well, then let us see their work. If it is evident that they performed the task more effectively, they deserve to be paid more money. And the Gemara responds, this is referring to tilling the land, where the quality of the work is not immediately apparent. So the Gemara asks, well, with regard to tilling as well, doesn't the employer know what they have done as he can examine the earth that they tilled? And the Gemara answers, the laborers dug a ditch that is now filled with water, and therefore the employer does not know exactly what they have accomplished. How deep is it? He can't tell now that it's filled with water. So if you wish, say that actually we are dealing with an employer who said to the middleman, hire laborers for 4 dinars a day. And he went and told them that they were hired for 3. And as for that which you said, why should they have a grievance against him, as they knew and accepted these terms, right? This was the first objection. Although they agreed to those terms, they still have a grievance, as they can say to the one who came to terms with them, don't you have respect for the verse from Proverbs 3:27? Do not withhold good from him who deserves it when it is in the power of your hand to do it, right? So if it's not that the middleman is maybe not even pocketing the difference. he just decides to ingratiate himself with his employer by finding guys to work for less, these other guys can say, what are you doing? This guy was willing to pay 4. We want to work for 4. We're doing the work that's worth 4. Why would you set up a deal with us to pay us 3? Yeah, we agreed to it because there was nothing else available, but we didn't realize at the time that there was a better deal on the table for this very work, and you got yourself involved. What are you doing? Don't withhold money from us. And that ends that section. After analyzing the circumstances of the case in our Mishnah about this middleman hiring other workers, the Gemara observes, it is obvious that if the employer said to someone that he should hire laborers for 3 dinars, and that person went and said to them that they were hired for 4, and they said to him, we agreed to be paid as the employer says. So in that case, it is clear that their minds are on any additional sum that the employer might have offered. And they certainly did not intend to accept less than the one with whom they spoke proposed. But if the employer said he would hire them for 4 dinars, and the middleman went and told him that the offer was for 3, and they said to him, we agreed to be paid as the employer said, then what is the law? Is it correct to say that the laborers rely on his statement, the middleman, as they are effectively saying to him, okay, we trust you that the employer said that which you reported in the employer's name? Or perhaps we're talking about a situation where they heard what the employer said, or they know that this employer has hired other workers for 4 dinars a day at other instances, so they have reason to know that the employer said he's willing to pay 4, and even if the middleman came and said he's hiring for 3, these guys know that the employer pays 4, and they came and rely on that knowledge. And in fact, the employer did say 4. So aren't they then entitled to what the employer really offered? And the Gemara suggests, come in here a resolution of this dilemma from a halacha, a law concerning the gett, the bill of divorce. A woman said to her agent, bring me my gett for me. In other words, she's going to appoint someone, could be a man, could be a woman, doesn't matter, but let's say it's a man, to act as her agent to do what? Right? To do what? If she's appointing this man to be her agent to receive the gett from her husband, then when the husband gives the gett to her agent that she appointed for this purpose, she's divorced. When her agent receives the gett, she's divorced. In the normal course of things, a Jewish woman becomes divorced from her Jewish husband when he hands her the gett, right? But sometimes, they're divorcing, they don't want to see each other, they're actually on different continents, a lot of different things can happen. So she can appoint an agent to receive it. Or maybe that's not what she appointed him to do. Maybe she appointed him to bring me the gett. In other words, the husband will hand this agent the gett, and he's now acting as a delivery man to give it to her. And when she receives the gett, that's when she becomes divorced. So does she become divorced when the agent receives the gett, or does she become divorced when she herself receives the gett from this guy who's delivering it? Depends on what kind of agency he was appointed to. So a woman said to her agent, bring me my bill of divorce. So knowing her husband was writing a gett, she asked the agent to collect the document and transmit it to her. According to the terms of his agency, the wife is divorced only when the document reaches her possession, as he was not appointed as an agent to receive the gett on her behalf. But the agent went and told the husband, your wife said to me, receive my gett for me. He misunderstood the agency, and he reported to the husband something that is different than what his principal, right, meaning the woman, the wife, said to him. Right? He tells the husband that your wife said to me, receive the gett from me. Now, this statement indicates that the wife had appointed him to receive the gett in her stead as an agent of receipt, which would mean that she is divorced as soon as the agent is given the document. And the husband said, take it in the manner that my wife said. It is with regard to this case that Rav Nachman says, that Rabba bar Avu says, that Rav says, even if the get reaches her possession, she is not divorced. Because the agent changed the terms, right, misrepresented the terms of his agency to the husband, and the husband thought that when he handed this get to the guy, that now he's divorced, right, and that she's divorced, which was not so. In fact, at that point, the whole undertaking is flawed, canceled, and this get and this delivery are all no good, right? We're going to have to start over. One can learn from this that the husband relies on the agent's statement, right? That's going to be relevant to what this middleman laborer said to the other laborers when he's hiring them, because they rely on his statement as to what the employer told him would happen when he hires these other guys. In the case of the husband and wife, since the husband was under the mistaken impression that he was interacting with an agent of receipt, he did not instruct him to deliver the document to his wife. He didn't need to do that. He thought that the guy received it on her behalf and that he's divorced now. He didn't have to give any more instructions. And therefore, the get was not transmitted in the proper manner, which is why she is not divorced at all. As if it enters your mind that the husband relies on her statement, she should at least be divorced when the get reaches her possession, in accordance with the terms of agent for delivery. And this shows that the statement of an agent is accepted as a faithful representation of the wishes of the one who appointed him. And Rav Ashi said, and now we're on 76b, how can these cases be compared? Granted, if the opposite was stated, in a case where the woman said, receive my get from me, and the agent said to the husband, your wife said, bring me my get, and the husband said, okay, here you are, as she said. The husband thinks that when he hands this guy the get, it's so that the agent will deliver it to the wife, and when she receives it, then the divorce is enacted. She told the agent, be my agent of receipt. So what she actually told him is that when you receive the get from my husband, it's now technically in my possession, the wife's possession, and the divorce has happened, right? This guy now misrepresents his agency to the husband. So the husband thinks that he's not divorced until this guy, takes it from his hand and does the traveling and reaches the wife and hands it to her. So in that case, Rav Nachman says that Rabba bar Avu says that Rav says, from when the get reaches the agent's possession, she is divorced. It would be understandable. It would be understandable they said that. Apparently, the husband relies upon her statement that the agent is the agent of receipt. Here, he said something different, and that's the problem. So alternatively, had Rav Nachman ruled, from when the get reaches her possession, she is divorced. That's not what he ruled, but had he ruled that, one could conclude that evidently the husband relies on the agent's statement, and based on that statement, the agent is designated as an agent for delivery. But there, in the case cited, where Rav Nachman rules that she is not divorced, it is not because the husband relies on one statement or the other. Rather, it is due to the fact that by means of his statement, the agent negates his agency entirely. As he said to the husband, I am an agent for receipt, meaning I am not to be an agent for delivery. He's essentially saying that he is not prepared to go to the trouble of delivering the get to her, which was what she appointed him to do. Therefore, even if he does ultimately deliver the get to her, he is an agent neither for the woman nor for her husband. No conclusion can be drawn with regard to the question of which statement the husband relies on, the statement of the agent or the statement of the wife. He doesn't know what the wife said. He only knows what the agent told him. But we know that the wife said one thing and the agent said another, but the agent just screwed up the whole thing, and that's why there is no divorce. Now, the Gemara had assumed, going back to our Mishnah, and it said that if somebody hires laborers and they deceived one another, they have nothing but a grievance against one another and no financial claim against the deceptive party. So far we've been saying that what that means is that the laborers deceived one another, meaning that one of the laborers hired other laborers and he deceived them by hiring them for a different rate than what his employer told him he would hire for. Now we're going to look at a different interpretation of what deceived means. If you wish, say that when the Mishnah teaches they deceived one another, it means that one of the parties reneged on the agreement. As this Tana, who composed our Mishnah, also calls a circumstance described by the term reneged, meaning that either the employer or the laborers reneged on their agreement. And for that situation, he also uses the word deceived. To him, deceived and reneged is interchangeable. And as it is taught in a Baraisa in a similar manner, with regard to one who hires artisans or laborers, and they deceive the employer, or the employer deceived them, they have nothing but a grievance against one another and no monetary claim. And the Baraisa continues, in what case is this statement said? When they did not go to the workplace, i.e. the employer reneged immediately. He said, I'm going to hire you. And they said, you know what, I'm not going to hire you. But they never went to the trouble of traveling to the workplace and, gearing up or buying materials or starting the work. None of that happened. He said, I'm going to hire you, and then he changed his mind. So in that case, there's no monetary claim. They can have a grievance against him. They can complain about him. They can sully his reputation, perhaps, as a guy who hires workers, but they have no monetary claim. But if donkey drivers think truck drivers, right? People who transport merchandise. But if donkey drivers went and could not find any produce to carry, or laborers went off to work and found that the field was too moist for tilling, then what? The guy hired them. They came, they showed up for work, and then something was wrong. They for whatever reason, they couldn't do the work that they had been hired to do. It's not their fault. Maybe it's not the employer's fault either. Maybe the weather changed. But for whatever reason, after they showed up, they can't do the work. Then what? Then the employer must give them their full wages to which they are entitled. So which is it? Is it the full wages or the wages to which they are entitled? That's the dispute. But he does not give them the entire stipulated amount, as a donkey driver who comes back loaded cannot be compared to one who comes back empty, nor can a laborer who performs work be compared to one who sits idle. Okay, they showed up. He said he was going to pay them. Now the field is too soggy to work. He has to give them something, but he has to give them the payment that they would have received after, 12 hours of backbreaking labor. He's got to give them something. What does he give them? The employer deducts a sum from the laborer's wages, paying them the amount that they are willing to receive, given that they do not actually have to perform the work, right? It's that minimum wage, where the minimum wage is what would it cost to have you sit around and do nothing as opposed to do other work. It's worth, everybody wants to work, even though they're willing to do backbreaking labor. But if they end up being paid to sit around and do nothing, they're just not going to get the same rate as if they had done the backbreaking work. Now, in what case is this statement that if they renege, they have only a grievance said? When they had not started the work at all. But if they came and started the work, then the court appraises for them that which they have done, for which they receive some form of compensation. How so? If they received standing grain to reap, for a contractual agreement of 2 sela for the entire field, and they reaped half of it and they left half of it, or they took a garment to weave at 2 sela and they weaved half of it and left half of it unwoven. So in these cases, the court appraises for them that which they have done. And the Baraisa details this appraisal. If the current wage for the part of the task that they had done was now worth 6 dinars, which is a sela and a half, as the price for this assignment increased, then either he gives them a sela, as originally agreed upon, since they do not forfeit their stipulated wages, or they finish their work and then they get the 2 sela. And if the current wage for the part of the task that they had done was worth a sela, he gives them a sela. This statement will be explained by the Gemara. Rabbi Dosa says, the court appraises for them that which must still be done. If the current wage for the part of the task that they had not done was worth 6 dinars, So he can only, i.e., he can only find laborers who will complete it for 6 dinars, which is the equivalent to 1.5 sela. So either he gives the first laborers a shekel, which is equivalent to half a sela, or they finish their work and they take 2 sela. And if the current wage for the part of the task that they had not done was worth a sela, he gives them a sela. And the Baraisa continues. In what cases, this statement said, i.e., in what circumstance are the laborers paid for the amount that they performed, and the employer has only a grievance against them? It is said with regard to a matter that does not involve financial loss due to the work stoppage. But with regard to a matter that involves financial loss, in other words, you have guys who come, they were hired to, sow the whole field, or let's say reap the whole field, and they reaped half the field and they decided to leave. Okay, now if you can easily find other workers to come in and finish the field, okay, so you paid a sela to the first workers for reaping half the field, and you paid a sela to the second workers for reaping the other half of the field. You were originally going to pay the first guys 2 sela for reaping the whole field. So in the end, your field is reaped, and you paid 2 sela. It was a pain in the butt. It didn't happen in a timely way. You had to scramble and find other workers. That's a bummer for you, but you don't have a financial claim because there's no loss. On the other hand, if you brought in these workers to reap your field for 2 sela, they reaped half of it and then they disappeared, and you can't find other workers to finish it, now you have a big problem. And if you have to go out and find other workers, and the only workers you can find that will finish the second half of the field are going to charge you 2 sela just for half the field, right? Well, then that's what it's going to cost. And why are you in this position? Because those first workers reneged on their deal. So perhaps in that situation, you either don't pay them, or you can say to them, you owe me what it costs me to have the work finished. So I gave you a sela, you need to give me 2 sela back so I can go hire those guys to finish the work. And he has a claim, right? So if he has no financial loss, he's just annoyed, he doesn't have a monetary claim. But if this reneging caused him financial loss, then he has a financial claim. And he has the right to deceive them. What does deceive mean? How could you ever justify deception like this? For example, he can say to them, I fixed a sela as wages for you. Come and take 2. And up to what may he hire their... In other words, what he can say is, okay, I hired you to reap the whole field for 2 sela. You did half the field. You're entitled to 1 sela for the work that you did, but now I have to go find other people to harvest that second half. Turns out no one else is available. And for me to go find somebody else to reap that field, I'm going to have to pay 5 sela. Very high cost. And you are going to be on the hook for that. And then they say, oh, well, we don't want to be on the hook for that extraordinary amount. So he says, well, that's your problem. Your choice is either finish for the amount that we originally contracted at, or you're going to owe me when I have to go hire these replacement workers. Obviously, they're more likely going to go and finish the job. Now, it's deceptive in the sense that maybe there is no other workers, period, and he can't find anybody, but he can say to them, look, I could find somebody for 5 sela, you're going to have to pay me that. That he can say because he's really just motivating them to do the job that they originally contracted to do. And what it says here, right, how does he deceive them? For example, he can say to them, I fixed a sela as wages for you, come and take 2 to finish it, and up to what amount may he hire at their expense? Even up to 40 or 50 dinars. He can pay other laborers far more than the first laborer's wages to ensure that the work is completed. He can say, I'm going to go do that, as if he's got these other guys online. I mean, he could probably find somebody to work at that exorbitant rate. But really what he's doing is motivating these guys to finish the job they already agreed to do. Now, in what case is this statement said, i.e., in what circumstance may the employer deceive them to such an extent in order to ensure that the work is completed? When there are no other laborers there in that place to hire. Since the employer will suffer a heavy loss, he may resort to one of these methods. But if there are laborers there to hire, and the laborers who reneged said to the employer, fine, go and hire from them, the employer has nothing but a grievance against the original workers who reneged. Tana taught the Brisa before Rav. The employer must give them their full wages. And Rav said to him, my uncle Chavivi, meaning Rabbi Chia, said, if I were ruling on this case, I would give them only the wages of an idle laborer, but no more. And yet you said that he gives them their full wages. Now this is when they come and there's no work to be done, right? He offered them to come and for whatever price to reap his field. And when they arrived, the field was too soggy to reap. So they can't go find other work for the day because they had a long walk. They can't do the work here. So how much does he have to pay them? Full wages or the wages of an idle laborer? The Gemara asks, but the Baraisa teaches concerning this very matter that a donkey driver who comes back loaded cannot be compared to one who comes back empty, nor can a laborer who performs work be compared to one who sits idle. So evidently, even the Tana of the Baraisa agrees that they do not receive full wages. So why are you asking, what does full wages mean? And the Gemara answers, the Tana teaches the Baraisa before Rav did not conclude it. And he was unaware of this limitation, which was why he commented that they do not deserve their entire wages. In other words, everyone agrees, it just hadn't been written out explicitly in the Baraisa as this rabbi had received it. Now, there are those who say that the Tana indeed concluded it before him, and this is what Rav is saying. My uncle said, if I were ruling on this case, I would not give them anything. And yet you said he gives them the wages of an idle laborer. And the Gemara questions this version, but this is difficult. How can one account for the difference between the ruling of the Baraisa and that of Rav's uncle, Rabbi Chia? And the Gemara responds, this is not difficult. As this case where Rabbi Chia would rule that the laborers are not paid at all, is referring to one who surveyed his land the night before and observed that it was fit to be tilled and hired laborers on the basis of this examination. It is their misfortune that something occurred in the meantime to prevent them from carrying out the task. And conversely, that case where the Baraisa rules that they are given some payment is referring to a landowner who did not survey his land the night before. Since he was negligent, he failed to check his own field, he must bear the responsibility. And this is like that which Rav has said with regard to one who hires laborers to till, and rain fell and filled his land with water, preventing the laborers from performing the work. If he surveyed his land the night before and did all he could, then this is the laborer's loss, as it is a consequence of their misfortune. But if he did not survey his land the night before, it is the employer's loss, and he gives them the wages of an idle laborer. And Rava further said, with regard to this one who hires laborers to draw water from a river or a trench to irrigate his field, and rain fell so that he no longer needs laborers, this is the laborer's loss. The employer does not need to pay them, as he could not have known ahead of time that this would happen. But if the river comes up and irrigates the field, this is the employer's loss, as he should have taken this possibility into account, and therefore he gives them the wages of an idle laborer. And Rava says, with regard to this one who hires laborers to draw water from a river or a trench to irrigate his field, and the flow of the part of the river used to irrigate the field stopped midday, well, then the law depends on the circumstance. If it is not prone to stopping, this is the laborer's loss, a consequence of their misfortune. But if it is prone to stopping, then one acts in accordance with this consideration. If the workers are residents of that city and know that this might happen, then it is the laborer's loss. If the laborers are not residents of that city and are not aware that this is a likely occurrence, then it is the employer's loss. I am almost done. Questions or comments, please get them in. So the Gemara asks, why must he pay them their full wages? Let him pay them for the additional time at most as an idle laborer. And the Gemara answers, when Rava said this ruling in this case, he was referring to workers, be'achlushe of mechoza, who become weak if they do not work. These laborers were accustomed to steady, strenuous work, and therefore sitting idle was difficult and in fact not enjoyable for them. So it would be different conditions. So as we see over and over again, we have to pay close attention to what is the custom in a region. What are the workers used to? What are the employers used to? What expectations do they have when they offer to hire or offer to work? without signing a whole employment agreement and agreeing to every specific term or what happens if something goes wrong, we have to have a good understanding of what it was that they thought they were agreeing to and what they reasonably thought that they were agreeing to as we assess who bears liability and who does not. Okay, 2 questions, one from Jonathan. Not that I had thought deeply about it, but it is interesting to know how old a pattern it is to hire a contract agency who provides contract workers for a field or an office or something. I guess I considered the companies who provide workers for the fields to modern advent from the economies of big landowners in modern days. I think a word was left out. To the fields to be a modern advent from the economies of big landowners in modern days, right? But not so much, right? We see that even in very old times there were middlemen who would go and hire workers, and then how much responsibility are they taking on? Are they misrepresenting what the employer, hired them to do or entrusted them to do or appointed them to do? And all of these different relationships and nuances produce different results. Very good. Joseph, just an overview observation. The overall patterns of the tractates usually are cyclical in the topics. We are back to reneging, exploitation, and getts, but in a new context. Exactly. And God willing, every time we encounter concepts that we've encountered before, now they're appearing in a new context, but we are becoming more and more familiar with those concepts, right? And every repetition is very good for us, right? It's very good for us. And in fact, Mishna means repetition, right? Repetition. It's through repetition that we learn these things. That's what I've got for us today. And with God's help, we'll be together again tomorrow at the regular Friday.